Hello, and welcome to Questions That Matter, where we discuss some of the interesting and useful work that we do here at TrustBridge. One of the areas that we focus on in our research is the regulation of the electricity sector. In the past few years, there have been growing concerns about their independence. My colleagues Renuka Sane and Chitrakshi Jain have recently written an opinion piece in the print discussing this very issue. Today, I have with me my colleague Chitrakshi Jain to discuss some aspects that they talk about in this piece. So Chitrakshi, tell me a little bit about the way that electricity sector is regulated in India today.
The electricity sector got independent regulation in the late 90s, when the country was looking to reform the power sector. Earlier, we followed a public ownership model of regulation, but there were many deficiencies with the way it was working. In 1998, the government enacted an Electricity Regulatory Commissions Act, through which this sector got an independent regulator. Each state was given an independent regulator, and they wanted to depoliticize the determination of tariff and other functions that were heavily politicized before. The Electricity Act of 2003 emulated the same model, and therefore, what we have today is the independent regulation model, which is working currently in the electricity sector.
Right. In your opinion piece, you point to two recent judgments, one by the Supreme Court and another by the Karnataka High Court. Can you tell me a little bit about these?
Yeah, sure. So the Supreme Court judgment was a three-judge bench judgment where they indicated that policy directions that are issued by the state government to the electricity regulator, the regulator is not really bound to follow those, especially when they interfere with their statutory duties. Now, the context of this judgment is a provision in the Electricity Act, Section 108, under which the state governments are in fact empowered to issue policy directions to the state electricity regulatory commissions, and especially if they are furthering public interest. The facts of the case involved the Kerala State Electricity Regulatory Commission, which had decided to not approve a few power purchase agreements, power sale agreements. And the state government issued directions under this provision for it to review those decisions. And the Supreme Court, in fact, said that this is impinging on regulatory autonomy. And this is, in fact, the regulator is not bound to follow these directions. The second decision that we allude to in our opinion piece is a judgment by the Karnataka High Court, where the High Court, in fact, invalidated some rules made by the union government on open access. And the argument advanced by the High Court was that the union government relied on some residuary powers in the Electricity Act, when the specific function of enacting rules on open access is very clearly articulated in the Act, and that function has been entrusted to the state electricity regulatory commissions. And the High Court was very clear in arguing that this interference is not permissible within the scheme of the Electricity Act. So those were the two decisions which we thought had in fact advanced the idea of regulatory autonomy and sort of set the balance right for once.
Right. In your view, do you think that the electricity regulators in India have been able to function independently so far? And what are the major challenges that they come by in doing so?
When we talk about regulatory autonomy, one could take the view that sometimes regulatory practice differs from what is stated clearly in the law. But there has been scholarship which has argued that in the Indian electricity sector, even the formal balance is tilted in favor of the governments. And one of the provisions that clearly indicates this imbalance is Section 108, where the state governments and can issue these policy directions. And even at the time of when the Electricity Act was being debated in the Parliament, there were some concerns about this provision not having enough checks and balances. So the first issue is that this formal balance is tilted against the electricity regulatory commissions. The second issue is that given that we have a federalized framework of governance, states may be differently situated in terms of how independently their regulators function. So that is the second issue.
Okay. What do you think the way forward is? What can we do to improve the state of regulatory independence in the electricity sector.
Yeah, so what we argue for in the context of these two decisions that we have discussed is that perhaps the legislative design of the act needs to be rethought, and these guardrails about the functions that are entrusted specifically to the electricity regulatory commissions have to be more clearly articulated, because Section 108 is clearly a provision that lacks that can perhaps be ambiguously interpreted. And the decision by the Supreme Court is a welcome decision, but perhaps the act is also showing its age, and because of changed circumstances in many ways, because we have a larger integration of renewable energy. So perhaps when we are rethinking the scheme of the act, this could be one of the areas where we can get better clarity.
Okay, thank you so much for sharing these insights with me. Thank you for watching, and please like, share, and subscribe this video, and stay tuned for more such useful and interesting updates on the work that we do here. Thank you.